Welcome to Zero. I am Akshat Rathi. This week, a landmark court case. Picture the scene. We are in the Peace Palace of The Hague, in a dark, wood-paneled room.
Please be seated.
There are 15 judges wearing black gowns and white cravats. The room is filled with people, all gathered to hear the result of a major climate case.
The court meets today to deliver its advisory opinion on the request submitted by the General Assembly of the United Nations on the question of the obligations of states in respect of climate change.
Among the audience is a group of law students from the Pacific Islands, who 6 years earlier set in motion the case that has now made it to the world's highest court, the International Court of Justice. The students wanted answers to two important questions. What responsibilities do countries have to stop climate change? And if countries don't stop polluting, will they get in trouble? 15 judges from 15 countries, including one from the US, heard submissions from more than 100 countries over the last 6 months. Then last week, the judges gave a verdict, a unanimous one, and it was delivered by Judge Yuji Iwasawa.
The court unanimously is of the opinion that the climate change treaties set forth binding obligations for state parties to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions.
The reading of the entire verdict is about 2 hours long, worth listening if you have the time, but here's the brief version. The court said governments have a legal duty to act on climate change, whether you're party to the Paris Agreement or not, and the countries that fail could be in breach of international law, even liable to pay reparations to the countries most affected. This verdict sounds like a big win on paper. Is it? And how will it change the legal fight against climate change? Here to answer these questions is Laura Clarke, CEO of ClientEarth, an environmental NGO that uses law to hold polluters to account. They are famous for taking organizations like Shell and even the UK government to court for not meeting their climate obligations. Laura, welcome to the show.
Thank you. It's lovely to be with you.
So I suspect many people are hearing about the International Court of Justice, the ICJ, for the first time. What is the significance of that court? What is its jurisdiction?
Well, the ICJ is the most important international court there is. It's the most senior international court there is. And so when it issues decisions like this, those decisions apply to all states in the world. So it's a hugely significant court and hugely significant decision. It's connected with the United Nations and it essentially opines on matters of international law regulating conduct between states. So what are states' obligations under international law? Where there are disputes between individual states, it can be asked to rule on a particular issue, to give an advisory opinion on a particular issue. And in this case, the advisory opinion, the decision on states' obligations on climate change, it was asked by a resolution of the UN General Assembly to give this advisory opinion, essentially saying, what are the obligations on states under international law to take action on climate change?
And you described on LinkedIn that this advisory opinion is a once-in-a-generation legal decision that is going to shape climate litigation for decades to come. So let's just start with the basics. Where and when did this case begin?
So this is the most extraordinary initiative that started in a student classroom in Fiji and was driven by the Pacific Island students fighting climate change. Now, as you and your listeners know, the Pacific Island countries, like lots of other small island states, are hugely vulnerable to climate change. They bear almost none of the responsibility for it, but they're on the front line of the impacts, whether that's, sea level rise or other impacts. And so the Pacific Island students decided they wanted to ask the International Court of Justice, the highest court in the world, for a view on what a state's obligations to tackle climate change. Now, that was then picked up and championed by Vanuatu in the first place, and then a number of other states, which then led to the UN General Assembly passing a resolution asking the ICJ to consider this question.
Student projects are really fun, very important, but a student project that then goes all the way to the highest court in the world is kind of unheard of. Like, what was needed to actually take what was a student project to that level?
It's extraordinary. I mean, firstly, to the leadership, the moral authority of these students, who are, I suppose, reflect various elements of climate justice, right? First, that they're from very climate vulnerable countries. Secondly, that they are the younger generation. And one of the questions that they wanted the ICJ to consider is, what are the obligations on states for future generations? And so you have young people from climate vulnerable countries driving this. But it developed this massive movement, a massive momentum of states getting involved and supporting, civil society getting involved in an enormous way. ClientEarth played a very small part in that, but there were so many others really giving that a sort of a momentum. And I think where we are now is a decision that is the most significant development in international climate law since the Paris Agreement. And it's an extraordinary victory for these Pacific Island students and for climate vulnerable communities everywhere.
And so Vanuatu takes this request to the United Nations, and the General Assembly says, yes, we would like to know what is the legal obligation of states on climate action. And the ICJ holds a hearing, and we understand it's the largest hearing that the ICJ has held. More than 100 countries made legal arguments, some of them against it, and we'll come to that. And so now we have this legal advisory. What does the legal advisory say? What is the verdict?
Well, if I can just pause a moment on your point around the number of submissions, because the court itself said in its press statement and summary, this was unprecedented in terms of the global engagement. There were more than 100 submissions, but there were also other interventions because sort of civil society organizations like ClientEarth can't submit in the normal process. And so others intervened with their own legal opinions, advocacy, and so on. And I think the other interesting thing to say about the process was the decision was adopted unanimously by the court, by all the judges. There was no dissent. And it was, I think, far more forward-leaning than most people expected. In a nutshell, what does the decision say? It says that states have binding obligations under international law to prevent significant environmental harm, to cooperate internationally and uphold fundamental rights in the face of escalating climate risks. Now, there's a lot to unpack there, but I think one of the really important things is it's very clear that climate action is not a matter of aspiration or discretion, but it's a matter of due diligence. It's an obligation on states. And that's really important.
And so we can understand when it's an obligation to a state, what are other obligations of states that we know already exist in national law and international law, and how does this verdict add to their responsibilities?
So there are obligations under international law in relation to sovereignty. For example, upholding sovereignty is a very good example that a country's borders and its territory are sovereign. So that's a very good example. One that this builds on, a principle of customary international law, is about transboundary harm. This sense that a state must not do something that harms another state. That sense that you're drawing on, the court looked at all the relevant international law, not just the Paris Agreement, but the UN Convention on the Law of the Sea, the Convention on Biological Diversity, or the Kyoto Protocol, all this different law that there is out there, as well as customary international law, and reached this decision that really sets out what states have to do. And then, interestingly, they unpack what that obligation means, including in relation to the private sector.
And so the advisory opinion states that, states must pursue the highest possible ambition, which under the Paris Agreement is to limit warming to 1.5 degrees Celsius. It also states that granting fossil fuel licenses or subsidies may constitute an internationally wrongful act, and that countries could be required to compensate or remedy the damage caused by their emissions anywhere in the world where the damage might occur. These are things that on this podcast we've talked for a long time, because the Paris Agreement speaks to many of those points. The loss and damage fund that was created speaks to the point of needing compensation for these. But how exactly does this opinion go beyond Paris Agreement? Because it's not just taking the Paris Agreement and the language underneath it, but also other international laws in consideration.
Yeah, I think what you have here is an incredibly holistic and authoritative statement and articulation of international law and how it applies to states' obligations that is then authoritative and will be sort of front of mind for any national level litigation, for example. It sets out very clearly, and again, I come back to this point around an NDC is not aspirational, it is an obligation. And as you said, it was really, what's really interesting, and I think you came to that point around, it's not just about, setting out NDCs, nationally determined contributions and plans. It's also about looking at what's happening within a state's territory. So stopping fossil fuel production, the granting of fossil fuel exploration licenses, the provision of fossil fuel subsidies, all of those could constitute an internationally wrongful act. So it's hugely interesting. I think in terms of the question about what could this look like in terms of reparations or further litigation at the international level, I think, we, along with the rest of the international legal environmental community, are still diving into the implications and really understanding them. But there is, of course, precedent for cases before the ICJ on transboundary harm. And so you could well see more like that. I mean, I don't want to go too far in terms of, setting out how it will work, but as a ruling, it gives a real shot in the arm to climate vulnerable communities looking for justice, for climate litigation generally, but it's also a really, really important advocacy tool in terms of, pushing states to increase their ambition, increase their action in what is the critical decade.
One thing that stood out for me, which I did not see coming, was that this advisory opinion says that countries that may be affected by climate change, especially climate vulnerable small island countries that may lose their territories altogether as a result of rising sea levels, will be able to retain their statehood even after the lands are sunk. Now, you have represented the UK for these small island nations. What is life like on those islands, and why does keeping statehood matter so much?
I mean, it's a hugely important element of the decision, which perhaps has not had as much pickup so far. But yes, when I lived in New Zealand as High Commissioner to New Zealand and High Commissioner to Samoa, I spent a lot of time in the South Pacific. It's really clear climate change is an existential threat to these communities. It's a day-to-day lived reality. And that's about both their way of life, but also the existential threat to their territories and therefore their sovereignty and their statehood. And the ICJ was very clear about that. It said that under the UN Convention on the Law of the Sea, if sea level rise affects the sort of outline of your state, if you like, that doesn't mean that you then have to revise your maritime boundaries. Your statehood is your statehood, even if your territory changes shape as a result of climate change. So that's really important in terms of international law, because as you can imagine, this is an area where geopolitics and climate change interact very, very strongly.
It empowers these countries to keep fighting, even if it gets to the level where they may lose their land. I mean, we are seeing some of these islands already starting to act. So Australia now has a climate visa that people from Tuvalu can apply to. And Australia says they can eventually give enough of them for all of the people living on those islands to move to Australia if they so choose or they are forced to. But going back to the point of the implication here, because as much as this is a big legal event, it is an advisory opinion. Yes, it comes from the world's highest court, but when you say that it's a once-in-a-generation legal decision, what do you think changes as a result of this?
So I think it's a very, very clear, you're right. There is no enforcement mechanism, right? There's no one's going to come along, following this advisory opinion from the, ICJ and sanction states for not doing the right thing. That's clear. There is no enforcement mechanism, but it is that extraordinarily authoritative articulation of legal obligations of states under international law. And I think the opportunity now is using it as an advocacy tool, firstly. So in the run-up to COP30 in Belém, we've got lots of countries still haven't produced their nationally determined contributions, others, not doing enough. So it will really push states to do more. It will help guide national courts. That's hugely significant because we are going to see even more. Climate litigation, as you know, has been increasing exponentially over the past couple of decades. It will increase even further. And every time a national court hears a court case, it will have the ICJ decision in front of mind in hearing that case. And I suppose, really, it's a very clear message to states everywhere that action can't be deferred and legal systems have to reckon with climate duties. So international law has to be interpreted in the current context of the climate crisis.
More from my conversation with Laura Clarke, CEO of ClientEarth, after this short break. Also, we're still looking to get a few more questions from listeners for an episode we are making this summer. Do you have a burning question about climate, green tech, or the future of the planet? Please send it to us in writing or as a voice memo to zeropod@bloomberg.net by Monday, August 4th. Thank you to everyone who's sent theirs so far. During the hearing, we did hear from countries opposing the view that states will be bound by climate action. We heard from Australia, from Saudi Arabia, from the United States, from China, arguing that their obligations are limited to the Paris Agreement, but they've lost. What was it that they were arguing for, and why did they not succeed?
There's a lot to that question, but it really comes to this point around discretion versus due diligence. And so this idea that actually, what you say you're going to do under an NDC is aspirational. It's at your discretion rather than being something that you absolutely have to do and you have to compel private actors to align and so on, which is where the court came out. So, so I think that's an important distinction. I think, one thing I would say is, this is not a new law or anything like that. This is just a confirmation or an explanation of existing law. So, obviously then each state will sort of take its own view on what it wants to do as a result of it. And we won't be surprised that some states won't do anything different as a consequence.
There are some 60 countries that have national climate laws right now, which means the majority of the world does not have national climate laws. Even when a country does have a national climate law, to actually make the country do what the climate law says it should do is hard. ClientEarth has fought this case in the UK, which was among the first countries to get a climate law, to actually get the country to deliver on those promises. And I know that you're waiting on this Labour government to actually put out their steps to meet the obligations that they have. So how does it affect countries that do not have national climate laws? in the first place? And how would enforcement work for them?
A couple of things to unpack there, I suppose. I think it adds to the imperative to have national climate laws. And at ClientEarth, we have been pushing and advocating and supporting for a while for climate laws as the kind of missing link between international commitment and real world domestic action and delivery. And so we've supported a number of countries with their climate laws. But how, you're saying how would, if you have litigation in a country that doesn't have a climate law, how does this decision help? Well, it absolutely helps because there are any number of ways in which cases can be brought. And one of the ways that's very, very clear is when communities bring cases related to human rights and climate change, where they say, my government is not doing enough to protect my human rights from the impacts of climate change. And if I give you an example of a case we supported in Australia, the Indigenous Torres Strait Islanders, who we supported to take a case to the UN Human Rights Committee, essentially saying that Australia's inaction on climate change was a violation of their human rights, a violation of their Indigenous right to culture. And the UN Human Rights Committee agreed with us and ordered the Australian government to do more and to pay compensation. We've also had the European Court of Human Rights issue its binding judgment on Switzerland in the case of the Klimasenioren, so the senior Swiss women who said that by virtue of their age and gender, they are much more vulnerable to climate impacts, to extreme heat, for example, and the Swiss government was not doing enough to protect their rights. So that's just one avenue whereby these climate cases can be brought, regardless of whether there's national climate legislation in place. And as these cases are brought, the plaintiffs will have in mind this decision from the ICJ, which is also really clear on the human rights element, where it says a healthy environment is the foundation for human life and human rights. And that's a really sort of remarkable statement. It says a clean, healthy and sustainable environment is a precondition for the enjoyment of human rights. And the right to an environment, to such an environment, results from the interdependence between human rights and the protection of the environment. So that's really, really, really important because most states are very clear on their obligations to their citizens from a human rights perspective. And so it's taking that across.
It's interesting to have these legal judgments. The Swiss women case is very interesting. You had the Human Rights Court say that, yes, you are right, Switzerland needs to do more on climate. And yet the Switzerland government rejected it and did not change anything as a result. Now, if we even go and focus on the ICJ itself, it released an advisory opinion in July 2024 stating that Israel's occupation of the Palestinian territories is unlawful and that Israel should put an end to this occupation. The UN General Assembly adopted a non-binding resolution to enforce that advisory opinion. But of course, here we are, nothing has changed. Israel's attack on Gaza continues. So why should we take this ICJ advisory opinion seriously? Because things don't change that often.
I suppose this goes to the point of how hard it is to effect change generally, right? It's sort of quite a philosophical question, isn't it? And, of how do you effect change? Where does power actually lie? How do you change terrible things that are happening, stop terrible things that are happening? There is no silver bullet. You can have the most perfect ruling, but ultimately you need the state to take action. And I suppose my answer then is that these legal avenues, your litigation, your advisory opinions or decisions, even getting the right laws in place are only part of the picture because you need political will and action, you need societal mobilization, you need behavioral change, you need businesses pulling in the right direction, and so on. You're absolutely right that when this decision is now out there, that doesn't mean that states everywhere next week are suddenly going to transform their work. But it will definitely push in that direction. And equips those that want to see more action, advocacy groups, lawyers, climate vulnerable communities. It equips them with another tool to push for that sort of action.
Much of the work that ClientEarth has done has also focused on companies. You, as a shareholder, sued a Polish coal company from building a coal power plant, and you succeeded. How does this opinion, which is very much focused on international law on countries, affect corporations, which are the places where most of the emissions are generated?
It's a great question. And of course, the ICJ is about state responsibilities and state obligations. So it can't directly hold companies or businesses to account. But what it did say, and I talked earlier about this question of states having a due diligence requirement to take action, that states have an obligation to regulate private actors. If a private company is producing huge amounts of emissions, then the state has a responsibility to regulate them and stop that harm. So I think that's a really important development. So if, for example, you have a fossil fuel company that's polluting with abandon, the country has to, under international law, regulate them and stop that. It's just another tool, I suppose, to drive corporates to do the right thing.
So you're not a lawyer. I am not a lawyer, but I am married to one, and you work with one.
So am I. I'm married to one and I work with them. I'm surrounded by lawyers. Yeah.
And one of the things that people tend to think of lawyers, and I think we should do some myth busting here, is that they are not creative people, but actually they are. And if anything, climate litigation is proof of what being creative with the law can enable, because the number of climate lawsuits have been growing and the impact from them is starting to add up. How exactly do you think ClientEarth's work changes as a result of the ICJ opinion?
Yeah. Let me just pause on your point about creativity, because you're absolutely right. And that's what's one of the most exciting things about ClientEarth and other organizations like this. You've got these brilliant, committed, clever people who are using the law creatively to affect change. And I think sometimes, often the law is seen as a tool to defend the vested interests of the status quo, right? But actually, it can be used in the right way for radically progressive means. And that's hugely exciting. So, at ClientEarth, we've long, taken law, corporate and financial law, human rights law, others, and said, how can we use that for better environmental outcomes? So that's hugely exciting. And I think that's often why we get such great support from the music and culture industries, because they're attracted to that creativity. How does it change our work as ClientEarth? Well, we're obviously deep into the implications for our work. It really provides an even stronger framework for the work that we're doing, the national level litigation against states, the litigation against corporates, but also importantly, the positive propositional work that we do when we support countries in getting the right national climate laws in place or the right regulations in place. And that's something that, I think often we're not known for. We're known for our sort of big bang cases when we sue people, but we do a huge amount, often below the radar, of supporting governments and authorities and getting the right regulatory framework in place for the renewable energy transition, for example, getting the right climate laws in place. And we're also training prosecutors, judges, working with community groups. And I suppose this decision, it strengthens it makes the roof over all that work much stronger, I suppose is the way I'm thinking of it. We're sort of building up, but the roof is stronger or the foundations are stronger. I'm mixing my metaphors, but it's hugely authoritative as a statement of international law. And I'm hopeful and optimistic that as a consequence of it, it will both push states to do more, but it will also strengthen climate litigation.
But we're also living through a time where perhaps since the 1990s, the skepticism of the international order is at the highest level. You have the US government pulling out of many international treaties. The Paris Agreement is just one of them. In such a time where countries seem to be pulling away, and it's not just the US, other countries want to be going in that direction too, how do you think the ICJ opinion actually gives more weight to international law?
Yeah, I mean, you're absolutely right. We're living in a time of extraordinary tensions in the international order. And the US is, there is a lot of US unilateralism. That doesn't mean, that's a real blow to multilateralism, but it doesn't mean the end of it. And I was at the UN Oceans Conference in June, and that really, looked like multilateralism absolutely there, focused on what is needed to protect our ocean. But all of this stuff is contested and it's difficult. And one of the ways that you protect international law is you use it, you exercise it, you get people involved and engaged. Because the really important thing about any sort of climate action is not letting it look like it's the preserve of the elites, it's, the government bureaucrats, or it's, civil society organizations. It is, reflective of grassroots mobilization. And I think that's really important. And the significance of this, it's significant in terms of that statement of international law in relation to climate change, but it's significant because it comes from such a broad mobilization of young people, of civil society, of states globally. And that is an articulation then of how many people want climate action, they want to see changes, and that should bring pressure on states, on businesses, on those who are in positions of power and make decisions, to make decisions that trend towards a safe and stable climate.
Yeah, I mean, as somebody who thinks about climate change all the time, and you do too, we just have to live in this world where there are two seemingly opposite facts that are both true. China is the world's largest emitter, but it's also the world's green tech superpower. That, multilateralism is creaking, and yet you had the European Union and China, the second and the third largest emitters, put out a statement saying they're going to try and make COP30 a success by submitting new climate goals.
You have to be able to hold multiple truths in your hands at the same time. I think that's really, you have to be able to sit with that complexity. But you're absolutely right. The international order as we know it is both under unprecedented pressure and more important than it has ever been in terms of tackling these threats to our global commons.
Thank you, Laura.
Thank you. It's been a pleasure.
And thank you for listening to Zero. And now for the sound of the week. That is the sound of a gas boiler being removed from a home. In the first half of this year, sales of heat pumps in Germany surpassed gas boilers for the first time, as the country moves towards cleaner forms of home heating. Read more about it on Bloomberg.com. If you like this episode, please take a moment to rate and review the show on Apple Podcasts and Spotify. Share this episode with a friend or with a creative lawyer. This episode was produced by Oscar Boyd. Our theme music is composed by Wonderly. Special thanks to Eleanor Harrison Tengate, Somer Sadi, Moses Andim, and Siobhan Wagner. I am Akshat Rathi, back soon. Hey, it's Akshat. Each week, you lend me your ears, and now I'd like to hear from you. Do you have a burning question about climate, green tech, or the future of the planet? Please send your questions to us in writing or as a voice memo to zeropod@bloomberg.net, and we'll make an episode answering them. Please do include your name and where you're based. Thank you.